Hello and welcome everyone to the second webinar in the Goodwin Critical Juncture for Privacy series. My name is Laura Leitner. I'm a partner at the Goodwin office in London and I'll be moderating this panel today. The last webinar we organized was focused on the US, and this webinar we will look at the privacy trends and key changes in a few global jurisdictions. To discuss these topics, I'm joined today by Clarisse Giraud, Bruno Bioni and Bruno Giancarelli. We're going to be talking for about 45 minutes. The audience is free to send us questions in the Q&A panel. We will be trying to answer them at the end, so we'll leave 15 minutes at the end for Q&A. So first of all, I'd like to thank the three panelists for joining today. Thank you for making time and agreeing to be here. I suggest we kick off the panel by everyone giving a short introduction to who they are, even though we all know who you are. It'd still be helpful what you're doing these days, what's keeping you busy, and then we'll kick off with the discussion itself. Clarisse, do you want to start?
Sure, thanks, Loïc, and hello everyone. Good evening from Singapore. It's 9 p.m. here. So my name is Clarisse, and I'm the Managing Director for FPF Asia Pacific Future of Privacy Forum. Been based in Singapore for 7 years now. And before that, I was in Paris for many years, and I've been in data protection for a little while now.
Bruno Bioni, do you want to go? It's going to be a bit hard with two Brunos on the. That's an unusual event. I've never had this happen, but yes. Do you want to go second?
Yes, thanks, Laurie. My name is Bruno Bioni. I'm Executive Director of Data Privacy Brazil, which is a space of articulation between two organizations and a school that delivers courses, and the second one, which is a research association, non-profit organization. And I also act as a legal practitioner here in Brazil. And recently I was appointed to the so-called Brazilian National Data Protection Council, which is a kind of a multi-stakeholder entity that facilitates the policy making alongside the Brazilian data protection authorities. Thanks for having me.
And finally, Bruno Giancarelli.
Yes, hi everybody, and hi Laura and thanks for inviting me. So I'm Bruno Giancarelli. I'm working in the European Commission, which is the executive branch of the EU, and I'm working for the department responsible for justice and consumer affairs, where I'm deputy to the director for fundamental rights and the rule of law. That's a bit long, and that includes responsibility, direct responsibility on issue concerning data flows and data protection. So one of my main responsibilities is to make sure that data can circulate and can be exchanged for all sorts of reasons, many different areas, with the necessary protections.
Thank you, and thank you all. I think we will start by addressing what we call the elephant in the room, which is Bruno. Do you want to chat a bit about the privacy shield? Because that obviously falls under your remit. And, you know, what can we expect? What's happening? What can we not expect? What do companies have to do? What do people have to think about?
Well, as you know, we have, in light of the invalidation of the privacy shield by the Court of Justice, we have been engaged in negotiation discussions with our US counterpart on a new arrangement, and there have been an intense negotiation, good progress. If I can summarize this, it's this time we need to get it right, and getting it right is getting an arrangement that can deliver that stability and legal certainty that stakeholders, all stakeholders and stakeholders expect, and that's what we are working on. And of course, this is and remains a priority for both sides.
Yeah, I think it's for many businesses also a big priority. Do you want to tell us something about timing?
As I said, this is not a question of timing. This is a question of reaching an arrangement that, by fulfilling the condition of the Schrems II judgment, can deliver that stability and legal certainty I was referring to. This is what we are working on, and this is what is a priority for us. Timing is in a negotiation. First, you would need to ask in a negotiation. I'm not negotiating by myself. I'm negotiating, or we are negotiating with counterparts, which are the US. So you would need to ask that first of all the question to both sides. But that's not important. Once again, the important thing is that this is it's a priority, and for both sides, and that we are working on it.
Obviously, whatever comes out of this, you know, it'll be subject to like scrutiny from a lot of parties. Does that mean that companies can just expect something like it was before, a privacy shield? You know, we all know how it used to go in the past, which is a lot of companies signed up. Unfortunately, also a lot of companies signed up and didn't do anything. It was a very useful solution in terms of, you know, low effort. For some others took it really seriously. I can't say everyone did it like this, but I'm expecting there will be some change there, right? Even if once you've agreed something, it may not be exactly the same as it was previously.
Well, I'm sad to hear that this meant low efforts for companies. I don't know what your clients would be thinking about this, but look.
It wasn't me, but we all know the research that came out of it. Someone who went onto all the privacy policies, they were just copy pasted. Apparently people just paid the fee, signed up. You know,
yeah,
there's a bit of a scandal
of course,
around.
A sustainable privacy shield or future arrangement replacing the privacy shield, and that we have always said that's true for any rule, be it the privacy shield, be it the GDPR, be it the Brazilian legislation, then it needs to be seriously complied with. And if it's not complied with, it needs to have serious supervision and enforcement. That's certainly essential for the sustainability of any future deal. What we're working on, as you know, is to make sure that any new arrangement will meet the requirements we have to fulfill in terms of limitations, safeguards, conditions around governance access to data, in particular access by national security authority, and redress mechanism in this area. That's what we are working on. Coming also to your question of timing, and I think, you ask by drawing a parallel with the privacy shield. Of course, that needs to be also understood in terms of timing. And once we will, we hope, reach an agreement, that's not the end of the story. This will be a so-called adequacy decision. So the European Commission will have to take a decision demonstrating in detail that what we would have agreed provides for the level of protection required. And therefore, it will mean that there will be a proposal made, that we have to go to a decision-making process that, as some of you may know, involves an opinion of the European Data Protection Board, what we call the scrutiny from the European Parliament, and then a vote by the member countries, the member states that compose the EU. This, of course, is not done overnight and involves a lot of scrutiny, absolutely right. So this is even before any litigation. It involves a lot of scrutiny, political scrutiny, legal scrutiny. I think we also seen, and we are learning, of course, from our experience with recent adequacy decision, the intensity of the scrutiny, the healthy scrutiny, which we are subject to, and that's a further reason to make sure that what we will agree on is solid.
How long does that second part of the process take in average? I know you can't put a time on it, but quite long, no?
We have recent examples with the UK and Korea. We're talking of months, not days or weeks. We're talking of 3, 4, 5, 6 months. If I remember well, the 2 UK adequacy decisions were we made our proposal last January, January 2021, if I remember well, and the final adoption took place in June. With Korea, it was July 2021, and final adoption December. That decision-making process, compared to other decision-making process, you probably think that this is quite short, actually, and quite efficient.
Yeah.
But I can tell you it's a very intense one, and one that involves us explaining, defending, providing information on the proposed draft decision we are submitting to the process. And I can imagine that after 2 judgments of the Court of Justice, there will be a lot of interest, curiosity, and therefore scrutiny on anything we would propose with respect to the US.
Yeah, and then I also assume once you're there and it's adopted, people know about it now. Individuals, data subjects, like I can imagine, even if they don't contest the privacy shield in itself, they'll be more likely to like enforce their rights. So actually privacy shield may...
Yes, sorry, I didn't want to interrupt you.
It may just become more burdensome anyway, signing up to privacy shield.
Well, that's a conclusion you draw, I think. The privacy shield, as any adequacy decision, is first of all, or any successful arrangement to privacy shield would first of all be guaranteeing 2 things: a high level of protection, but also bring a lot of simplicity to companies by ensuring that there is a mechanism in place on which they can rely without having to enter into a case-by-case assessment to transfer data. So I think that if there's such an interest for these negotiations and such expectations on what these negotiations could lead to, it's because on both sides we see advantages, and I think that businesses on both sides of the Atlantic are looking for that stability and certainty. But of course, everything is public. Our draft decision is first of all made public. We have a very transparent system, and if this is negotiated and if then this is adopted, as we did previously, public awareness of citizens of what we call data subject about the right is of course important.
Yes, and increased. That's everything I wanted to ask about Privacy Shield. Bruno, Clarisse, do you want to ask something more? We've got him now on the panel.
No, I think Bruno is already, on the grill. Just a general comment, which is that these negotiations are extremely important from an APAC window. I mean, not all, EU-US data transfers have an impact in Asia, but I think what is at stake there is the capacity to demonstrate that key partners are capable of looking eye to eye and basically building something that stands, that's strong, and it's a sign of trust, right? And this is what we're all after, and this trust that everybody's talking about and is so sorely lacking between governments, between businesses, between consumers and businesses, between businesses themselves, right? I think if the EU and the US can agree to a very ambitious agreement like this one, it would be extremely positive to the world because it shows that trust is still possible and we build from there. I mean, from an APAC window as well, what's going on? All the conversations taking place at the OECD on government access to data, to take a bit of pressure off Bruno. There are other circles where
Absolutely.
These discussions are taking place. They're crucial, and I really hope, was very happy to hear that the negotiations that had stalled are starting again, because in terms of symbol, it's extremely important. So just a comment. I mean, it's not from the outside, for someone who's not involved in transatlantic conversation, I can tell you everybody's watching. For sure.
I can agree more. They've never stopped, so they have not restarted. They've never stopped. And what I think Clarisse said, which is very important, because of course we are all, and we tend, and it's good that Bruno Bioni is there because he comes from another area of the world. We tend to be all very focused, and it's a very important relationship for the transatlantic relationship. But this issue, compared to a few years ago, is a global issue. There is an increasing demand for standards, not only as regards to privacy, if you want, how commercial entities handle data, but also in the field of access to data by government. I think it's very good that this conversation has started and has started strongly and seriously, because we need a common understanding and we need common standards. So what is happening at the OECD is very important. The data free flow with trust initiative of the Japanese. This is not a European initiative. This is not an American initiative, where trust is very much about trust, in which democratic governments governed based on the rule of law can access data for all sorts of legitimate reasons. I know also, and Bruno will probably tell us more about this. This is also an important issue in Latin America. So I mean, it's only together that we can address these matters. And I understand that what we're working on the US is also very much observed by others, because meaning if in a certain sense, I guess, if we cannot agree, who can agree? I guess that's a bit also what Clarisse was saying. But I also think that more and more you will see that conversation also in other contexts, including more multilateral contexts.
Yeah, and I think that brings us to a second topic, which is obviously, you mentioned that GDPR standards, well, GDPR, common standards, developing, you know, in those areas, but also broader, right? The privacy laws of other countries. There is some sort of development towards more privacy laws, but also some standards, I believe. I think it would be helpful if both Bruno and Clarisse could talk a bit about what's happening in their region, and we could like discuss and see if there is actually convergence, if there's like, you know, they're seeking for, you know, common ground or not, or if there's systems that are completely opposite to what the GDPR is doing. Or I don't want to keep referring to GDPR because I obviously don't want it to be the measuring stick for everything. But Bruno, I don't know if you want to start.
Yes, I can. Thanks, Tori. I think here in Brazil, I think it's worth to highlight. The Brazil is, I think, the biggest democratic country that approved comprehensive data protection law. So we have right now like under 200 million of people with those guarantees. And recently we just also approved an amendment of our constitution to guarantee and to include data protection as a fundamental right. So a lot is going on, and I think all efforts in terms of trying to move towards a convergency is going on here in Brazil. And why I'm saying this, because here we are just like 2 or 3 years that we passed our LGPD, and we are also trying to put a lot of energy and efforts in trying to review in a short time the legal regime of our Brazilian Data Protection Authority, because right now it's not like an autarky, so it belongs directly to the public administration. And of course, there is some kind of problem in terms of independence, at least in terms of full independence. And we are working on that. And I think in general, terms of speaking, this is a common trend not in the global south, but at least in Latin America. When we are talking with our friends from even Argentina, Uruguay, or Chile, all of them are looking for this, how we can work better or design better the institutional arrangement to enforce data protection laws. So this is one thing that I could highlight, at least in terms of the regulatory scenario in Latin America. But with regards specifically to Brazil, in Brazil, we think a really complex legal scenario in terms of enforcement, because here we have the so-called Consumer National Data Protection System. So not only the Brazilian Data Protection Authority could enforce data protection rights, but also all entities from federal, state, or even municipal level enforce data protection through the consumer defense. So this is a really different with, we establish a comparison with regards different jurisdiction, and it's not necessarily a bad thing, because then we can allocate better the resource and the efforts to enforce properly the law. And recently, the Brazilian Data Protection Authority concluded a cooperative agreement with the Federal Agency of Consumer Data Protection here in Brazil. So there is this kind of cooperative institutional arrangement in order to also give legal certainty of how these more than 700 entities in different municipal and states here in Brazil could enforce the law, because of course there is a big problem in terms of legal certainty if one specific PROCON here in São Paulo applies legitimate interest in one direction and another PROCON in Bahia or Rio de Janeiro applies legitimate interest in an opposite direction. So we are working on it, but the good news is that the Data Protection Authority is concluding several cooperative agreements in order to coordinate the enforcement actions here in Brazil. And the last one, I think it's also important to highlight. Here in Brazil, in the last 2 years, we have already had 2 important cases at our Supreme Court. So the highest level of the judiciary is already enforcing data protection as a fundamental right. And this is a really big issue in terms of convergency, because when you have like an adequacy decision or even an international data transfer agreement, the assessment that is made is not only the administrative level in terms of enforcing data protection, but also the judiciary, this holistic enforcement overview about it.
It's interesting. So do you feel, because obviously they're working on this coordinated enforcement response, which may not fully be in place yet, but do you think once it is in place, enforcement could actually be driven a lot like quicker and faster than it has been in the EU? Because in the EU, it took 2 to 3 years to really ramp up. I think we're almost there now. I can see Bruno saying no, but there's been a while where there's not a lot of enforcement. I think 9 decisions in total in 2018. I was looking at the statistics. Now they're like in the 900s, but at this point. But do you think it would be faster? It'll come off the ground faster because you'll get these 700 entities who can start enforcing?
Actually, they already started because here we have some administrative case that are being leading or to the Consumer Data Protection and Consumer Agency, the secretariat that belongs to the Ministry of Justice, or even other entities likewise PROCONs. So they are already operating, enforcing the law. What is the big issue that I would say? And I think here, one of the directors of the Brazilian Data Protection Authority has a good metaphor to explain it. Miriam Wimmer has already said that the Brazilian Protection Authority could act like in a wholesale market by interpreting and enforcing the law structurally at the macro level, while the national system of consumer could act like at the retail market by applying the law and enforcing the law, but always according to the interpretation and the guidelines prescribed by the Data Protection Brazilian Authority with regards to the daily cases of non-compliance of the law, so the micro level. Will it work? I don't know, but again, I think that's a good scenario when we have this cooperative agreement made recently. It was just the end of the year. And then I think we have to wait if those promises are going to materialize or not.
Thank you. Do you feel the same trend is happening in other South American countries?
This is a really peculiar and a singular, let's say, flavor of data protection and enforcement here in Brazil. So far, as I could talk with our Latin friends, there is no something similar in other jurisdictions. And here on the top of that in Brazil, we have also a long historical and legal tradition in terms of facilitating the filing of class actions. I don't know that I do know that the GDPR also update the legal framework for it in order to facilitate those legal remedies. And here in Brazil, we have like 30 years of it by already operating. So here also in Brazil, like the Public Minister's Office, the Defensorias Públicas, even NGOs could do it, and without fancy like a high barriers of entry. For instance, as a rule, there are no court or even attorney fees to be paid by who lost the cause. So this is really different in comparison to other jurisdictions. What is the result, I think? The trend is that the judiciary is going to enforce the law, of course, because of this legal scenario. But then we'd like to see and to realize if the judiciary at least will do it by being inspiring to the guidelines of the Brazilian Data Protection Authority, because then we're going to have a clash between the administrative level and the judiciary one. But again, it's not one thing that is bad, a negative point. Could be also a positive one, because as we have like in the literature, the administrative level could be captured, and then the judiciary is the legal is the alternative one to operate as a counterbalance. And once you have the judiciary also to enforce the law, put pressures in the administrative level to operate and to gain legitimacy, to have a final say, a final word about the interpretation of the law. So it's like a really tricky and a mosaic, let's say, scenario. But again, I'd like to be positive. I think our Brazilian Data Protection Authority is doing a great job. The 2 years of the operation, they conclude at least 4 cooperative agreements with the Electoral Superior Court, with the Senacom, the Consumer Data Protection Agency, with the Federal Public Minister's Office, and also with the security incident team here in Brazil. So they are doing something that is quite unique here in Brazil, because only with 2 years, they are concluding several cooperative agreements in order to get this coordinated action in terms of enforcing the law.
Thank you. That's really interesting. Bruno, I saw you shaking your head at some point when I asked you a question. Do you want to add something?
No, because I'm very happy. I was shaking my head, but maybe I should have smiled, because I'm very happy to hear that people want more enforcement. I remember when we concluded the negotiation of the Gdpr, the big concern, especially of businesses, was there will be all these fines, overnight. If I remember well, the date of the entry into application was the 25th of May, between the 24th and 25th of May. Of course, enforcement is something serious that requires time, especially on big cases, on complex cases. You need to collect the evidence, assess it, build your case. So, and if we look at other areas of regulatory areas, that big investigations take time. You have also to hear the parties. It shouldn't surprise anybody. And indeed, we are seeing now the result on some big cases, the one that make the news. Now, we had the last summer in the EU, there were the sum of, total of fines that were imposed was 1 billion. For one summer, it's not. But, everybody forgets that data protection enforcement is a mix of different things. It's guidance. It's meaning on more mundane case, maybe settlements where DPAs can play a big role in putting into contact and in finding a solution. But it's also a lot of cases that maybe don't make the news, but that are that result in decisions. Because I don't know when you were taking your 9 figure case, but 2020, so it's not like last year, but it's the year before. It's 110 decisions taken in Europe on the what we call the one-stop shop. So only decisions on cases that have the cross-border effects. If we look at cases that have a pure national effects, of course, the number are much higher. Not saying that everything is perfect. The real cultural revolution of the GDPR is about enforcement, is about having DPAs working together. That takes time. But we see an improvement of the cooperation, because we are facing the same challenges that Bruno was mentioning. You know, how to ensure consistency of interpretation and enforcement in a large space. Brazil is a federal state. From that point of view, the EU is also close to a federal state, because we have one law, but 27 different systems, legal systems. So those are important challenges that require to also maybe look at procedural aspects and others. But certainly what we see is that privacy is taken more seriously, including by enforcers. And the litigation also gives a very, because litigation at the Court of Justice, it's just the tip of the iceberg. But the number of cases, I think we have now more than 20 pending reference for preliminary rulings before the Court of Justice in the area of data protection. That's the tip of the iceberg, and it shows that at the level of the lower court, there is a lot of litigation on data protection. I think we'll see more of that. It also connects, and with that it connects the question you were asking, Laura, about individuals making use of their rights, or organizations representing consumers, representing individuals, making use of some of the mechanisms Bruno was explaining. So we see really, and I know that many think that this is going too slowly, but we are moving to, I would say, to theory to practice, or we're moving from the books to practice, and that's something that, of course, we are observing with a lot of interest.
If this is like a timeline from theory to practice, I wonder if Clarisse can add a bit of color on where we see Asia. Asia is like, it's a big continent, so I don't expect you to like focus on every country, but maybe, the ones everyone's wondering about.
Continent.
Yes.
It's a region, it's huge. No, I mean, just to do a transition, because I was a regulator in Europe before, right? And I can only agree with Bruno. There is no such thing as a small case when you're a regulator, because every single case creates a precedent. And you can go to court on the stupidest case, on the very tiny complaint that can make an entire procedure collapse. So there is no such thing as a small case. And that's very important to bear in mind. Anyway, so in Asia, things are different, because a number of jurisdictions are less mature, but there's a lot happening around here. And you were mentioning, Laura, it's actually not a continent, it's an entire region. It's the most populated region in the world. Two biggest countries, China and India, not to name them, are here. And even the small countries in comparison are very, very big. So the populations of Indonesia, Vietnam, I mean, them huge markets, and there's a lot of attraction here. So I think it's really important to make this point, even though it looks a bit like crashing into an open door, but especially for an audience that is not used to Asia and does not live on Asia times. Well, I mean, you have to remember that Asia is not a block, and that every single country is actually different, needs to be looked at, and there is not a cohesive set of countries and an organization that can iron out all the differences between them. So it's basically a mosaic of very different countries. And I'm just putting in a word here for the teams that are working in APAC, for the companies that are represented here. I mean, just think of them like, they are not saying no for a reason. No reason. I mean, it's a difficult job. All the laws are moving at the same time. The systems are extremely different. The economies are different. The expectations are different. So it's really an interesting region. And for me, coming from Europe, the sophistication is totally different. The sophistication of Europe's data protection system with GDPR at the heart is unique, of course, but the complexity in Asia lies elsewhere. It's in the necessity to navigate very, very different developments with a lot of interest from outside Asia, but also a growing intra-Asia movement that really takes us a bit away from GDPR and typical EU-US kind of conversations in particular on data flows. So this is truly a global discussion. And actually, we see the European Commission, well, we don't travel nowadays that much, but I mean, Bruno was in Japan, was in Korea, was, you know, has been traveling quite a lot. It's really a really important region. So another remark is that we tend to look at Asia as kind of the region that's catching up, right? And it's a bit condescending, frankly. It's not a region that's completely catching up. Some of the oldest data protection laws are from Asia. Some systems are extremely mature, so Japan, Korea, of course, Australia down there, and New Zealand, and Hong Kong, and others. So actually, maybe it's just that we don't pay enough attention because it's the part of the world that sleeps when you guys are awake and the other way around. So definitely it's worth paying more attention to what's going on around here. What strikes me every day is that here the energy is incredible. So the digital economy is booming. Countries really are, you know, every day more interconnected, very diverse economies again. But Asian economies and societies are highly interconnected now, and between themselves and with the other regions of the world. And therefore, the data protection systems are increasingly interdependent. And this is where we run into a number of difficulties because the laws are still very different. So the very good news, we have to be positive. Bruno Bioni said that he was positive. And I think to be in data protection nowadays, you've got to be positive and optimistic, otherwise you get nowhere. But the good news is that more countries adopt data protection laws, and that's a really good thing. Privacy expectations are on the rise. We don't have an Asian max frames yet, but probably not. But lots of people actually exercise their rights. We have really interesting cases, even in China, where people go to the court and defend their rights. I mean, and it's not a joke, it's serious, and they really push things and change things. So what businesses aspire to when we do not see that happening is clarity and certainty, which is a word that Bruno Bioni mentioned earlier. And I think that's probably what characterizes the region the most. It's the lack of certainty. And at the same time, some countries, like typically Singapore and others, are, you know, moving in the same direction and trying to build interoperability or convergence, whatever you call it, but try to build a number of solutions that bring countries together and facilitate data flows. And, you know, even if it's not perfect, at least, you know, systems sort of come together. Gdpr has certainly provided a source of inspiration for many countries. The latest laws that were adopted or that are still in the making, including in China, by the way, in India, in Thailand, in Indonesia, even in Vietnam, they all sort of drink at the source of GDPR, you could call it that way, but these laws are not mini GDPRs for that much. First of all, because a number of jurisdictions, actually, some laws pre-exist at GDPR, and they do not at all rely on the structure, a legal structure, which is European even. So in Australia, New Zealand, in Japan, or in Hong Kong again, Korea, even Singapore, the laws actually are very different. And there are big outliers. So with data localization at the heart of the data protection ecosystem, and these raise a lot of questions, of course. So China and India, but also Vietnam, and to some measure Indonesia. So I don't know which countries you want me to touch on. There's a very large variety. It's a region that is incredibly dynamic and where I believe people should watch more. And I know Bruno Bioni, the European Commission, and many others are actually working with a lot of stakeholders around here, because there is some creativity here. A number of regulators want to be at the origin of solutions and not, you know, be leaders and not followers. And so we see lots of really interesting developments, like the conclusion of digital economy agreements, and what do we do with trade and economic partnerships with data flow clauses in them, more adequacy decisions coming. It's really a fascinating place to be at the moment. Anyway, very general comments. Tell me if you want some more specific comments now.
I think it would be interesting to hear a bit about what's happening in China. We got a lot of questions about that when the new laws came into force, like quite unexpectedly, and then, you know, everyone was up in arms. And then what's happening there now on the ground? Maybe elaborate a bit about India as well.
Okay, so first of all, I'm still surprised that people are surprised that the data protection law was adopted in China. The PIPL has been in the making for so much time, like so many years, maybe even a decade, right? The first draft, which was actually based on the directive at the time, 9546, was released and discussed, you know, quite extensively at the time. The PIPL, which came into force in November, is basically, building on a number of pre-existing texts like the cybersecurity law primarily, and also it works, it works hand in hand with the data security law of China. You can actually, because in the interest of time, could I basically refer you to, I'm sorry, it's a bit of self-promotion, but on the blog of FPF, there is actually a very long presentation and analysis of the PIPL that we did with a number of my colleagues. And I think it really sums it up really well. I think you can say there are lots of commonalities on substance with GDPR, and that was clearly the intention. The drafters, when you know them, you've worked with them, they've been tracking developments in the EU extremely closely. Not only in the EU, they've tracked CCPA, they've looked at Brazil, they've looked pretty much everywhere. And if you're on WeChat and you follow, some guys who are involved in these procedures, you can see like within 2 days, a week, the EDPB opinions got translated into Mandarin and circulated extremely widely to networks of DPOs that were feeding into the conversation. So, I mean, honestly, I'm still surprised that people are surprised. There's a flurry of development, lots of implementing regulations are still lacking, and that again creates uncertainty. It's not easy. We're waiting for basically a number of implementing regulations to know where the CAC, which is the lead enforcement agency, where it is headed and how it will basically apply a number of key provisions. At the heart of everybody's concern is, of course, data localization and the fact that a large majority of data for critical information infrastructure operators or network operators in certain conditions has to be kept onshore. There are exceptions to these requirements, but they're not entirely clear yet. And in any case, they require a specific consent of the individual, and that typically the conditions for obtaining this specific consent are not clear. So enforcement, for now, we're not too sure. I mean, I'm not a practitioner, right? So I can't tell you for certainty. What is certain is that there is a lot happening on the ground, whether the local regulators or at the level of municipalities, but also in the courts. There is case law based on the, not so much the PIPL, but the pre-existing provisions. Also, remember that now in China, data protection, personal data protection and privacy are basically part of the civil code. There's a specific provision in the civil code that makes it into a personality right, very civil law style of legislation. And people go to court on the basis of that as well. India is a very important country to do follow what's going on in India for sure. The Joint Parliamentary Committee on the Data Protection Bill of India that was supposed to adopt a report that would lead directly into the adoption of the law, of the bill as law. Actually, we're still waiting. The bill has not been adopted. There's not a law yet, and we keep waiting and waiting. I think 2022 might be the year, but even the best experts have given up on giving a date. Here again, heavily based on GDPR. What is very interesting to refer to what Bruno Bioni was saying is that here as well, the law was drawing on a landmark decision of the Supreme Court of India, which really read data protection and privacy into the constitutional rights of Indian citizens. Basically are protected by a constitutional right to data protection and privacy, and that's extremely strong, right? But then, unfortunately, based on that ruling, over time, the text has been, moving in the direction of being also a text to regulate non-personal data and digital sovereignty. And there's a bit of a lot in that text that turns it into much more than just a data protection law, and that certainly has slowed down the process. And there are concerns also to the scope of exemptions that apply to the state. And that's something which might lead to further challenges in the Supreme Court. So it's not only in the EU, right?
Yes, that was going to be my question, because I feel in the EU, what keeps us busy these days is state access to data.
India is going to it keeps everybody busy.
Yeah,
definitely.
And is that as much of a point of attention as well in the rest of the region? Obviously, Bruno, like everything we seem to be doing in the EU, the Google Analytics case law now, privacy shield kind of stems from concerns about government access to data. Is that the same in other regions, or do you think there's less attention to that?
You're asking me the question?
Yeah, or anyone who wants to respond to this.
Well, that's really a sticky question. To be frank, yes and no. So actually, again, a bit of self-promotion. Last year, we, together with two practitioners, we actually published an article on Shrimps 2 in Asia Pacific, because I was really curious to know, how basically companies were looking at this and implementing the ruling worldwide, because of course government access to data is not an EU-US exclusivity. I mean, it's a global challenge, and which is why the work at the OECD is so important. The companies, of course, they protect their data, they protect their customers, they protect their employees. They are looking, at what data government access, and they put on a number of measures which could have been considered supplementary measures under the ruling of the Court of Justice, anonymization, data minimization, you name it. But we don't really talk about it. It's not something that has been placed at the heart of the regulatory ecosystem in Asia Pacific, with nuances. And of course, I mean, it's very hard to be generic here, but with nuances. And it's really interesting to see, Bruno was mentioning that Data Free Flow with Trust initiative was launched at the initiative of Japan. Japan and Korea have actually made the effort of clarifying their own regulatory frameworks on government access to data, because they found that it was a key element to bring forward in the adequacy decisions, of course, with negotiations with the EU. But beyond that, it was also a requirement from their citizens. So, it's truly a global challenge, but maybe the frameworks are not ready to take the shock of such a complex discussion yet.
Yeah. Bruno, do you want to say anything about this before you hop off?
No, I fully agree with Clarisse, and the work at the OECD is a reflection of that, because what are the two underlying objectives of that work? First, that trust in the conditions under which government access data is part of trust, and therefore, if you want to facilitate data flows, you need also to address that part of the equation. And the second element is the need, which is recognized by everybody, us, Japan, the US, and many others, to draw a dividing line, that this is an element of the dividing line between democracies, rule of law countries, and authoritarian regimes. The problem is not, of course, there are very legitimate reasons to access data, but you do it in a certain way, with certain safeguards, with certain oversight mechanism, with a certain access to justice in countries that share some basic values. And I think that was, for instance, very much part of the Japanese, and is very much part of the Japanese data free flow with trust initiative. So of course this is complex, and that's also this balance between the balancing act between privacy and national security is a complex one, and you will not see an international treaty on this in the next 2 weeks. But the fact that actually countries that this conversation exists, and not only this conversation, but that the need to have some common understanding, and if possible, some common standards in this area, that need has been identified, is a huge difference with the situation only a few years ago. And indeed, I'm very sorry, I informed the organizers I have to leave, but I guess the good news is that there will be more time to discuss other areas of the world, which were actually a lot of things, and a lot of very interesting things happen elsewhere than in the EU and the US. On Asia, I want to mention, it's true, there's a lot of developments of legislation, but another aspect of Asia and Latin America, which is very interesting, is the regional dimension. The role that certain regional organizations, such as, for instance, ASEAN, play in Asia, in developing, for instance, model clauses that facilitate transfer of data amongst those Southeastern Asian countries, but that also, by doing that, facilitate transfers within the region, but also between the region and other partners such as the EU. And we are very closely working with ASEAN to see whether there are ways to bridge our sets of model flows. That's a very concrete examples and tangible example of what cooperation can mean today. So thank you very much, and sorry for having to leave.
No worries. Thank you for being here, Bruno. I'll maybe shoot the word to Bruno Bioni if you want to comment on this as well. You know, both what actually in my head I've moved away from like access to data, but more the regional initiatives across the whole region. That would be interesting.
Yeah, with regards to Brazil, I think there are two important issues to highlight with regards to that matter. The first one is that here in Brazil, we do not have like a comprehensive data protection law in terms of law enforcement, as you have in European Union or even in other countries. So that's why the Brazilian Parliament is working on it. So there is a pending draft bill to be discussed to set the rules of the game about how the government and law enforcement agencies could not only access, but literally process data in order to prosecute. And the second one, which is a good thing, is that the Brazilian Supreme Court is recognizing and enforcing data protection as a fundamental right. So the judiciary is assessing if the government access to data is proportional, is necessary, and all the legal reasoning in order to balance two competing interests, the interests of the law enforcement agents and the interests of the data subject in terms of liberty and other fundamental rights that are facilitated and completed by data protection as a fundamental right as well. So this is the big issue for the next 2 years, how the Brazilian Parliament will react and we will advance with this really important piece of legislation, while in this meantime, we have here not only other legal guarantees that are prescribed by the penal code, the telecommunications law, even the Bureau of Rights of Internet, marks to the Internet, but mainly how the Brazilian judiciary will do these assets and will strike properly this balance.
Thank you. Clarice, I don't know if you want to add something about regional efforts.
Yeah, I think that's actually Bruno did the other Bruno. Now there's only one, so it's going to be easier. When I say Bruno, there's only one. The other Bruno made actually a really nice transition around the regional conversations in Asia. There are different levels actually in terms of institutions, if you will. ASEAN, so the Association of Southeast Asian Nations, so 10 nations, Singapore being one of them, of course, at the heart of the system, has been advocating for more coherent, more not harmonized, because really harmonization is not a word that we use in Asia. It's very European to some extent. So we talk about convergence, right? And interoperability, but they've been advocating really very strongly and quite successfully for the development of more consistent tools, data protection frameworks, and starting with a cross-border data transfer mechanism that is currently the standard model contractual clauses in ASEAN. Tomorrow, hopefully also a joint certification mechanism that would be articulated with Gdpr. So that's the plan. Right now, really the focus is on the standard contractual clauses. But we see that the regulators themselves also, their networks are being strengthened. So there's now a data protection forum within ASEAN, the regulatory network of Asia Pacific privacy authorities, the APA forum, it's called. there's an increasing number of regulators coming from this side of the Pacific, because it covers the two sides of the Pacific, but now truly Asian regulators are really stepping up their participation, and there's a lot of support there. What strikes me, honestly, for someone who's been in, the European, working for an American think tank in Asia, so combining all this, these different experiences, do not underestimate the capacity of, companies, societies, generally individuals to take the thing in their own hands and build their own system. They don't necessarily need people from outside to come and tell them how to do things, not at all. There's an eagerness to get things right in ways that are commensurate to the energy of the digital economies in some country. If you, well, again, we can't travel, but if you, when I used to travel for work or for leisure around the region, when you see the energy there, the young populations in Vietnam, again, in Indonesia, or even in Thailand, everywhere, highly connected, very aware. It's, of course, maybe it's an elite part of the population, but it's a growing one. We have not mentioned, and maybe I'll stop here because I could talk about Asia forever, but we have not mentioned the importance of the role of data for development, and how eager some countries are to take these conversations also to drive an agenda of modernization and development. And that's particularly true in Southeast Asia, but also in India. And that element is often lacking in conversations with, for instance, the EU or the US, because they are developed economies, right? But when you're in a region where there are economies of very different level, and that's probably the case also, of course, in Latin America, you need to adapt the discourse and look at things a bit differently. And that's why some conversations around, for instance, government access to data will not be considered a top priority, because the priority is really to have a dynamic digital economy, to put your people online, to give jobs to young population. So it's an entirely different conversation. We have to accept this diversity.
I've got a question on the side panel, actually, in the Q&A, which kind of slots into this. I thought it was a question that I didn't anticipate you may have seen is, how do you think the GDPR concept of data portability can work globally? Which is a funny one, but actually it goes to what you were saying, the focus maybe somewhere else. How do you empower people to use their rights? And I don't know if you want to both comment on that.
My mic is still on, so I'll take advantage, and then Bruno can take over. But data portability is truly now in most data protection laws in Asia. It's been introduced recently in Singapore. The consumer data rights in Australia is operational already. And actually it supports a number of mechanisms, in particular on open banking. That in Asia, we have a number of very strong financial hubs, of course, Singapore and Hong Kong and others. And Japan, of course, and Korea are extremely advanced. Data portability is already operational, right? And there are, very advanced systems there that really are worth looking at. So that's open banking, but we can look at, data from utilities, for instance, are covered by the Australian consumer data right, for instance. I mean, it's not yet entirely sure how it's going to work. The same challenges as in the EU, right? But the concept is there, definitely.
Yeah, so that portability is not like a right of the data subject, but also a duty of the controllers. And I think that's quite important to highlight, because then we came to the 1,000,000 of question, how to operate it, how to materialize this duty and the right. And here in Brazil, we have a really interesting cooperation or at least action that came from the central bank. So that portability is already in being implemented, at least in the financial sector. So I think that action tells us a lot about it, because it's quite difficult to think and to operate data portability in a horizontal way. We have to think about to do it properly sectoral based. So I think we are developing really interesting initiatives at the financial sector, properly probably the next one is going to be health sector, the second one, the telecommunications sector, and so on. And then I think this is also quite important to highlight, because then necessarily data protection authorities, and the Brazilian one, of course, will have to sit next to the other agencies and the regulators to implement it. So that's why it's so important to think about the dialogue being constructed between data protection authority and the telecommunication agency, between data protection authority and the health regulator, and so on. And then I think it's like wave by wave, and a really long journey to implement it.
Thank you. Thank you both. This is really interesting. I'm sorry to say we're going to have to put an end to it because we've reached 2 o'clock. Thank you, Clarice. Thank you, Bruno, for participating. And with this, I will finish the session.
Thank you, everyone. Thank you, Laurie.
Thank you, everyone. Thank you, Laurie.